Welcome to Bloomberg Law. I'm Lee Pacchia. Joining me now from Washington, D.C. is Scott Michel. He's the president of the law firm Caplin Drysdale. Hi, Scott. Welcome.
Hi, Lee. How are you?
Pretty good. So I thought we were going to be talking about Congress reforming the tax code, but I guess we're going to be on another topic today. What happened?
Well, best I can tell from reading the same newspapers that you read is that tax reform is not quite on the front burner.
Well, that's okay, because this is a great time for us to talk about the Foreign Account Tax Compliance Act. That's the law that President Obama signed into effect sometime last year. It comes online January 1st of 2013. It has some very aggressive measures in making sure that financial institutions and banks and asset managers operating outside the United States take steps to rein in tax evaders, people who owe taxes to the United States government, but for one reason or another are not paying. I want to unpack this entire bill, but let's start off very slowly. Who is covered by this bill?
The Foreign Account Tax Compliance Act, otherwise known as FATCA, applies to every single financial institution located in every country in the world. It applies to other entities as well, but the core components apply to what are called foreign financial institutions. So even if a bank in Portugal or Brazil or Switzerland has no footprint in the United States whatsoever, FATCA applies to that financial institution.
And what is the bill looking for?
The bill is aimed at addressing the problems of Americans holding undeclared funds in foreign accounts, obviously outside the United States. And it's not exactly that this is a non-problem. There has been a lot of activity, IRS enforcement and other activity in the last 3 years or so, aimed at rooting out Americans who have had money located in foreign accounts and haven't told the IRS about it and haven't paid the taxes on their investment earnings in those accounts. In fact, the IRS brought in some 30,000 people in 2 voluntary disclosure initiatives in the last 3 years on this. But there's a perception that a good number of Americans still maintain these undeclared accounts, and Congress last year decided essentially to take a swat at this beehive with a neutron bomb. In implementing, in passing and enacting FATCA, which requires foreign financial institutions throughout the world to spend hundreds of millions of dollars to come into compliance with a statute aimed at enforcing U.S. law.
Right. There's been much discussion about what banks and financial institutions need to do to get ready to come into compliance with FATCA. What exactly, what are some of the big top line items that jump out at you on the requirement side? What do companies need to be doing right now?
Well, there are 3 series of publications or guidance issued by the Internal Revenue Service to give financial institutions some direction in this. And I would imagine most financial institutions, unless their compliance and tax people have been living on Mars, are well aware of FATCA and what it requires. The core components for the financial institutions will be to engage in a retrospective look back at their roster of accounts to attempt to root out any accounts that may be beneficially owned by U.S. taxpayers. And then at the same time to implement a reporting mechanism on a prospective basis to ensure that anyone who comes into their bank who is an American is identified as such, and then to implement a program of automatic annual disclosure to the Internal Revenue Service of every single American's account, as well as the amount of money in those accounts and the amount of income earned in the accounts.
That sounds like quite a bit to do. What happens if a company or an institution can't or won't comply with this law? What happens then? What's the enforcement mechanism look like?
FATCA is designed around the notion of a contract, that there is a contract between a financial institution and the Internal Revenue Service to engage in this due diligence and disclosure activity. If a financial institution either doesn't sign the contract, or if they sign the contract and then later on are found in breach of the contract, the enforcement mechanism is a punitive withholding regime. The IRS will withhold 30% of all U.S. source payments back to this financial institution.
Wow.
And this includes investment income, interest, dividends, capital gains. It includes the gross proceeds of any sale of assets, and it applies to the institution's entire portfolio. So you could have a situation where a non-U.S. account holder is invested in the United States, and if the bank gets hit with this 30% withholding, their non-U.S. account holder suffers the downside of the 30% withholding.
So it sounds like FATCA has teeth. The financial system, I think this is an understatement, has been under some degree of stress as of late. That said, are financial firms ready for FATCA?
Well, my sense from taking the pulse of some financial institutions around the world is that they are struggling mightily to bring their systems into compliance with what FATCA will require. And I don't believe any major financial institution is anywhere near ready for FATCA. In fact, the IRS implicitly recognized this in the third round of guidance when they essentially deferred some of FATCA's provisions into late 2013 and early 2014. But I know that there is a lot of activity in this space, and that financial institutions are having to, engage consultants or work internally to spend an enormous amount of money to come into compliance. I mean, I would note that FATCA appears to be the product of an analysis that lacks any sort of cost-benefit thinking. I think there's a good chance that the amount of revenue that FATCA will raise over the next 10 years will be greatly exceeded by the cost that foreign financial institutions and to some extent U.S. financial institutions will have to incur to bring themselves into compliance with the statute.
So what's going to happen in terms of timing? Is the deadline going to get pushed back in order to allow financial firms time to come into compliance with this law? How is this all going to get resolved?
Well, there is a lobbying frenzy, I would call it right now, of various financial institutions, trade associations, non-financial institutions that are affected by FATCA, who are commenting on FATCA to the Internal Revenue Service in the hopes that the IRS will make implementation less costly, will make perhaps delay or defer some of the core components, at least to the extent that's consistent with the congressional mandate, and potentially even carve out exceptions for financial institutions or even jurisdictions where the potential for real cheating is fairly limited. I mean, for example, right now there are probably close to 1 million Americans living in Canada, and these American citizens are now receiving letters from their financial institutions to the effect that their accounts will be subject to disclosure under FATCA, and it's creating an enormous amount of activity in Canada. You may have seen the financial minister for Canada has issued some criticism of the United States. So there is a lot going on out there on this. I think the U.S. has not done itself any favors in terms of how we are perceived by not just the financial institution community around the world, but by other governments, in the sense that there's a sense that we are imposing our will extraterritorially on other countries to help enforce our own tax law.
So where did the Obama administration go wrong in this? Is the whole bill or the whole law flawed, or is this something that could have been fixed with minor tweaks at some point in the legislative process? What would you have liked to have seen done?
Well, I'm not sure that the blame lies entirely with the administration. I mean, there were a series of hearings in Congress back in 2008 under Senator Levin's stewardship regarding cheating in foreign accounts by Americans who had accounts overseas. My sense is that the legislation was the product of these hearings. I think an effective regime one could come up with an effective regime to deal with this problem. Like I said, it's not exactly that it's a non-problem. I think it would behoove the financial institutions involved to try to come up with an alternative. Now, Europe has an alternative mechanism called the European Savings Directive that allows for the payment of withholding tax among various countries, but does not require the disclosure of the names of the account holders. I don't sense that the United States law enforcement establishment would sit well with that kind of strategy. So it may be that there are ways one can curtail the burden of FATCA, but as long as the sort of core statutory structure remains in place, I don't see any way around it for financial institutions other than to come into compliance.
All right. Well, certainly lots of work to be done. We'll have to see how it goes. Scott Michael from Caplin Drysdale, thanks so much for joining us today, sir.
Thank you. It was a pleasure.
If you'd like to learn more about the issues we just discussed, be sure to check out our offerings on BloombergLaw.com. I'm Pacchia. Thanks for watching.